you can start.
Yes. Yeah, that's it. Thank you. So am I audible to everyone?
Yes, ma'am.
Yes, ma'am.
Thank you. So today, guys, hi, I'm Ojaswini. I'm also a registered patent agent, qualified in last exam at 2018. For this session, I'll be dealing with drafting of patents, but for today and tomorrow, we'll be having a general discussion on patents. It's just general topics, like what are the patents. You must have already got trained up in the act. I think at the sections I hope were trained, but most of the part is to say we'll have a interactive session more for these two classes. Like for today and tomorrow, we'll be interacting with each other. So it'll be like if you people have any other queries in between, also you can raise your hand and you can ask me. So this is mostly it's like a general discussion type. So can you go to the next screen, Brijesh? Yes. So yes. So generally, it's a general thing like whenever as a patent agent, you'll be having a different types of applicants, or you can say before they become applicants, they'll be your clients. So they'll come from different fields, like they can be a student, or they can be from R&D department and everywhere. But the problem is even the research people who are already into the research of particular solution for an existing problem kind of thing, they still like even they lack a bit knowledge or the patent information. Most of them still, especially in India, we can see that they lack information. It's not awareness or kind of thing, but they lack information of the patent information especially. And so most of the things, like for the researchers, there are different stages. They define problem, they review different types of literatures already existing, and they prepare these different types of solutions. But here, for us to file a patent, we have one problem. Like we have to search globally for novelty, inventive concept, but we get protection only in the applied country. So it is jurisdiction. So here again, to get the novelty, to overcome the novelty. I'm sorry. Is it fine now? I can. Someone saying like, is it echoing or is it fine now? Yeah. Okay. Fine. So yes. So for not only for the researchers, even for the student also, if they come up with an idea, they should. They want to protect their idea. Before protecting their idea, they have to do a minimum research of some patent information, especially, or it can be non-patent information also, like your research articles or kind of thing. And for every patent draft, we keep in mind, especially while drafting the claims, we need to point out the novelty and inventive concept. That is a must in our patenting, in drafting, especially in drafting. So next slide, please. So this is the kind of thing which we need to be aware. Like we need to show them or guide them or the applicants in the right path, that are they aware of some at least few patent information before they want to protect it under patent. And again, this is a patent of paper. We can just come see, not everything can be patented here. Some people will come like, most till date, most of them, they want to patent the research work, but A patent is only given to a product or a process or both together, but not for your general theories or idea. In general, idea is also not patented unless it can be shown in a form of a product or a process. I mean, not entirely, like there is no need for us to show a prototype of a product kind of thing. We can deliberately show it in a kind of system, especially we go with the application patents also. So for them, we use the already available hardware units, but how this together works with this application which we are using on this hardware, that brings out the inventive step in such applications. So so to check whether we can patent it or we can go with the research which is protected under copyrights, we have to check how much you have to check your IPR laws, that is which is copyrighted, which is patentable and everything. And we should also see whether these if they want to protect it, we have to see the anticipation concept, that is it already displayed in the public disclosure? If it is so, then what is the time period? So it should be before 12 months of such publication or presentation in front of the public. So that comes under section 29 to 32 of the anticipation, below the anticipation. Next slide, please. So we know this patent involves technology. So it's a techno-legal document or your patent document. So the claims are techno-legal part, and it protects a product or process or both in one patent. But it should be that product and process also, they should complement each other. It should not be some product and the product and the process should not be different from the product. They should complement with each other. And it's always like novelty and inventive concepts to be brought together in the claim drafting. And we already know that it's 20 years from the date of filing, and we can protect it. And so the owner of the patent, who is generally the applicants, they have the freedom of making, using, and selling it. And it is, as I told, it is generally territorial. The protection is territorial, but to overcome the novelty and inventive step, we have to check those concepts beyond our jurisdiction. So we have to also check the other patents also from other countries which are already filed or published and everything, to see the application has at least a part of novelty and inventiveness. So we cannot say that entire product should be novel or inventive, at least a part which makes the major difference, like a small, that arrangement or the arrangement of such component, or you're using something alternative of the already known thing, but with some alternate component, it is bringing some enhanced performance in the product itself. Then that part only, so we have to claim that replaced part or alternative part as a novelty or inventive, but we cannot claim the whole thing as novelty or inventive. We have to see those things. And who can apply, the individual, organization, legal entities, and everyone. And it is we have in India we have 4 jurisdictions, 4 different jurisdictions: Delhi, Mumbai, Kolkata, and Chennai people. So this jurisdiction also, it is already given in your act. So far, if anyone wants to share your ideas or want to ask, you can, or I'll proceed further. Someone has given the chat. No. You can go to next slide then. So the patentability criteria I'm saying, so novelty, novelty is in the case that we have A, B, C components in a product X, so which are known. And if we replace some component A, B, C with other component, but we are getting the same structure kind of thing, but we are using different components, so that is new. We can consider that as new. And inventiveness is, in terms of inventiveness, is a bit tricky one, where we have to overcome in each application. So it should bring, we need to characterize or differentiate the concept of any, if it is a physical product, if you're using ABC as the different components, so we are replacing B into D. So now we have to show the inventiveness in the form of, for B, this is the performance, the object used to perform in this scenario. But if we replace the alternative of B with D, now there is some increase in the level of performance, or maybe the device might have become more compact, or the ease of use is good in performance of time performance, or it is using less power consumption is reduced. So these all comes under inventiveness concept. And industrial use, definitely it should be industrial. I mean, the product, if we are showing the idea into the product or process, then it is definitely an industrial. And also apart from that, we have to check that they doesn't fall under section 3 and 4 of our patent act. So section 3 is completely, we have clauses of different, they have defined it like what cannot be patentable. I'll explain why they were claiming that why it cannot be patentable in detail. And section 4, it is related to atomic energy. So we have to see like anywhere the atoms, protons, neutrons, those concepts fall, then your application will be reviewed by the atomic energy body, the government agency. And if they feel that it is not related to atomic energy reactions and everything, but we are using those general idea to bring it into a product or a process, then it will be going into the further stages of publishing or reviewing of for examination. But if such kind of concepts is brought into our application, then definitely it will be reviewed by that company. So next slide. So non-patentability criteria, we know that we have sections from 3A to 3B. So now for everything, I'll give you a few of the details things, but if you have any more doubts in those sections, I can explain. But few things I want to just point it out why exactly they are saying it's not that. So dimensions which are contrary to the existing natural laws, we can say it is they can claim like, yeah, this can be done, we can show it or kind of thing, but in reality we have to prove a point if such kind of concepts are there. So if it's something contrary to natural law, it is not possible unless if you show it in form of a product or a process to them. Okay, I'm sorry. I just tried to. Now, can you hear me, guys? Is it clear?
Yes, ma'am.
Okay, sorry for this. So next, guys. So anywhere we cannot claim anything 100%, especially in machines. We'll have different types of number of contradicting issues when a machine starts working. So we cannot anyway say 100%. And it is contrary to public security or morality in terms of any weapons kind of thing. Or I have given an example of some process of cloning of animals, or a kind of, we are saying that we can clone these hard parts and everything. So they are also not patentable. Those concepts are also not patentable for us. And next slide, please. It's generally, it may cause harm to the public safety and security. And coming, we cannot claim for the mutated plants or animals, especially we cannot patent them. And we can also, because modifying the genetic identity kind of thing, that is your research work. But unless it proves if we are bringing any industrial applicability through those mutations, like if they are used in which can be used on a mass scale to solve any problem for the public, then we can see, but we cannot claim for those organisms. We can claim for the process which we are using such kind of organisms, but not for those organisms. Next slide, please. Yeah, scientific theories, there's a theories, but if that theory is implemented into a product or a process, then it is patentable. But not only theory, it cannot be patentable. It's a research work protected under copyright. Next, guys. Yeah, and discovery, even the discovery also, it is a copyrightable. It is already existing in nature. We did not create it, so it is not that. And if that discovery product, if we use in to get a new product or a process, then that product and process can be patentable. Being the discovered product, being a part of a component, but we are creating an entirely new product out of that, then that is patentable. Next, guys. Mathematical methods and algorithms. This is the main, a lot of issues are coming nowadays. So these are some major skills which we use. We can copyright those solutions which we have come to solve the problems which we are using with existing theories and kind of thing. But we may decrease some steps, we may alter some steps kind of thing. That entire procedure can be copyrightable, but it cannot be patented because those are some manual skills, and also they lack technical aspects, technical concepts in them. So our patent document is a technical document. We have to show our technical aspects in the claims also to prove that document. Because especially related to software, because software nowhere software is patentable, but still we apply patents for the applications. So how we can overcome this? We have a separate guidelines for applications. Under those guidelines for software applications, we also include this mathematical methods, business methods, and other algorithms into, we consider, we use the same concepts for this also, how to overcome this. But generally, if we want to claim for a formula or a solution to a mathematical solution or mathematical formula, then those cannot be patented. Next. And method of playing games. This monopoly is patented, it is known actually. So only the patent is granted to the board, whatever the cards they were using and the design of the board, that got patented, but not the method, whatever the process they are giving, the steps of process which we follow in the monopoly, the booklet, that is not a patent matter. That is a copyrightable, that is a copyrighted, it's protected under copyright. That method is not patented. Only the board, the design, the structure of the board and those dies and those cards, whatever the cards they have prepared, that is the patentable method. So this, because this is also considered as a metal skill, we can use various, like now other company X can come with different structure of board, with number of different types of cards and everything. Even that board can be patentable, but the process, the procedure, how they are playing and everything, that cannot be patentable. Next. Because the method of playing games does not involve any technical concept. That is the whole logic behind why these are not patentable. Even the business method also, there is no technical aspects involved in the business method. So business method is something we are bringing into sales, profits and everything. So it involves money transactions over here. Yeah. So again, we might get confused, like what is business method? Most of the time, we may use some kind of algorithms, or we can use AI algorithms kind of thing to see. As example, we can say screening of recognition, face recognition for entry into the office kind of thing. That is a technical aspect totally, but we are using that for our official purpose or kind of thing. Now, in the same way, a business, if you see a consultancy, psychiatrist consultancy firm where they want to just analyze the facial emotions of a patient kind of thing. See, analyzing the facial expressions and emotions, that is completely a technical concept. But they say in a business method, like they say, like we have this packages, the scheme where we use all this kind of thing. That package and scheme is not a patentable matter. But whatever they are using, the method, how they are doing the process, that is entirely a technical concept. That can be patentable. How they are screening the face, how they are extracting the facial features, and how they are able to say that, okay, this person is genuine. He is, while speaking, he is making a good eye contact and kind of thing. That thing That is a technical concept where we are using the image processing. So everything falls ahead. Image processing, we are segregating, classifying the different types of emotions, and we are also classifying the multiple number of images into those categories, whether he's genuine, like he's providing eye contact, so and so. So it's completely technical. But again, this whatever the schemes of packages that business or the firm will offer, that those are business methods. So those packages schemes, they cannot be done. But whatever they, if suppose they have come up with those good image processing modules to screen a good to provide good quality images and give an accurate results of analyzing their facial expressions and everything, then that method is patent. So business method, in the case, they are only going with money transaction. So that is not patentable. Next, guys. And also treating of human beings, the type of surgery they're doing, the procedure and everything, that is not patentable. So it is generally thing is our patents, it should be used for huge, I mean, on large scale, and also it restricts to one person who owns it. He has to give permission to a number of people to use his idea or kind of thing. So surgical process kind of thing, it is no way. It is not used for industrial purpose. It is only used for case-to-case study, and it cannot be patented for one person. The way he performs the surgery or kind of thing, no, it cannot be patented. Next, guys. And also aesthetic creations comes under copyrights, whatever thing, because it doesn't involve any technical thing. It is completely in art kind of thing. So it varies from person to person, and it cannot be used. I mean, they cannot be even produced on a mass scale, also large scale. So it is not a patentable matter. And you can argue like books can be on large scale, why it cannot be patentable? Because books, it is a general idea. We are just giving whatever, even the technical books also, it is a kind of a source for the educational purpose, so it cannot be patentable. Next, guys. And presentation information, whatever the presentation I'm giving it today, it's just a copyrightable material. Even though I'm using this Microsoft Word and everything things, but I'm just using and keeping it in one place. It depends upon from person to person. So I'm not giving an industrial, I'm not producing on a mass scale and distributing it. So this is not a patentable matter. It is just a copyrightable. Next, guys. And traditional knowledge. Yeah, here also we have some concepts like especially in medicines. Generally, we will see number of patent applications which will be filed, and we have those. Each medicine comprises of some components like turmeric or pepper, or some herbs which are already existing things. Entire medicine can be done, can be patented, sure, but if that the process, like we cannot just claim that this herb is going to cure this number of illness which is already known in the community, which is passed to us from traditions. We cannot claim first because it belongs to the community. It doesn't belong to one person here because it is passed from generations to generation. So here for a patent we have limited. The ownership is limited. It cannot be a group or a community ownership for a patent. It is a limit. We have limited amount of ownership here existing for a patent application. Next slide. And also for the topography of integrated circuit, this falls under 3F, arrangement of the known components of all these capacitors, resistors, and everything. We are arranging it in a different ways to get a more compact design. So on a layers, in different multiple layers, we are just arranging the known devices. So it falls under the layout. Layout itself means like it is an arrangement. So it goes under 3F category, and we cannot protect this topography or the arrangement kind of thing. Yeah, under section 3.0. So we have a separate act for this. For especially for the topography of integrated circuits, we have SICLD 2000 Act especially. But yeah, till now we have only two applications filed, and it's not well aware among the people. So only the arrangement falls under, is not patentable, but the product can be patentable. Next, guys. So here, so whatever discussion, like we also have section 3D, 3E. 3D is an enhanced efficacy, especially we see in the pharmaceutical. It should provide whatever I said. Enhanced efficacy comes under the inventiveness. We need to prove the inventive, how much it's giving more advantages if we replace some element, kind of thing. And the 3 is mere admixture. I mean, we are just mixing up all the things, kind of thing, unless it brings generic effect, kind of thing, like it's bringing more different kinds of advantages from the known thing, then it can be better. But it's showing the same results or same advantages, even though you might reduce some components, kind of thing, but the result is same, then it cannot be better. Anything else, guys? I think yeah, anyone wants to speak? Any doubts in the section 3 or 4?
No, it's fine now.
Yeah. Okay. So generally, while drafting a patent application, we give to the applicant, I mean, we consider that person, the person who wants to apply for the patent is an applicant. He can be inventor also. Inventors can come, but the applicant is the owner of the application, patent application. Inventors are not. So applicant and inventor can be same. Again, they can be same, they can be different again. So oh yeah, I'll continue. So coming to the before drafting, what are the criteria we need to see? Guys, this is general discussion, but for the examination, you will be provided a entire information, whatever I'm speaking now. This is the we say invention disclosure. So this will be already provided to you in the form of question. So you need to find out, I mean, you need to find out different, I mean, we have different categories, like subsections or sections in the patent draft, like field of invention, background of the invention, summary of the invention, or object or scope of the invention. It comes into one place, that summary, object or scope. Then we have a brief description of drawings and detail, and finally comes claims and abstract. So all these are the different sections in a patent document. This is a general introduction for you. So in your question, you can find all the data in the question itself. It just needs your, I mean, you have to read the question twice or thrice. So you can just arrange the given information in this subsection. So it will be given to you everything over there except claims. Claims you have to draft it from the information itself. So here also, first, before drafting, we'll be finding all the information together. So if the applicant comes like, okay, now we want to file a patent for this product kind of thing, it consists A, B, C, and everything. So we have to see, we have to like check what A, B, C. So what are the physical aspects of it, or technical aspects of each component, physical attributes, like what type of material is used, or what are its temperature resistance. If we go with details, these are some of the variations which we need to get it together to claim for us to provide multiple dependent claims for an independent claim. So before drafting, we have to have an invention disclosure, a complete disclosure. There shouldn't be like if the applicant, in the case he's unable to provide us details, complete details, then we have a provision of filing provisional application under section 9(1), and later within 12 months of such filing, we can go with complete specification also. So provisional specification doesn't consist of claims. It may not even consist of drawings also. So when drawings are not in place, then there is no detailed description also. So our main idea is to block the date. To have a priority over application, we are just blocking the date. So to have, to just secure, because someone else also may come and file the same, but he might come with a complete idea and everything, and they might claim it properly. But so to just avoid that, if we are unable to do it, if they want to do it quickly to protect their idea immediately, but they are not yet confident about where it goes. So they have a buffer period of 12 months to come up with a proper alignment of their ideas and everything. So to secure the date, we are going with a provisional filing.
Excuse me, ma'am.
Yes, yes.
Now that we are like discussing about this priority date,
Mhm.
could you please explain us like what is difference between priority date and the filing date? Like there is a bit confusion.
Okay, so filing date, the date where you're filing your original application is ordinary and not original. Ordinary application is a general application. You're a resident of India, so you're filing it in India first, so that comes under ordinary application. So for that, your priority and the filing date will be same for a complete specification. If it is a provisional specification, the filing date will be considered as a priority date and a filing date. You understood, right? Priority date is same, and it is an ordinary application. For that ordinary application, maybe you want to go to file a divisional application. Divisional application comes in a scenario. Let me explain an example. See, there is an agricultural machine for which at one place we need to just replace some appliances to use it for multiple applications. Okay, so now this
may I interrupt?
yes, Mr. Muralidharan, you were saying something?
Yeah. In the case of patent of addition, if patent of addition is filed later, priority can be claimed as a main invention, right?
Yes, the filing date will be its priority date.
So
Date of that is the prior. Yeah, your prior document, that is your ordinary document, will become
even
your
though patent of addition is filed later than the main addition, the filing date, priority date will be different. Filing date.
Yeah, the filing date of patent of addition will be different, but it claims the priority over the ordinary application.
Yes, the actual claiming of the priority date will be the main invention, right?
Yes, yes, yes. Even for the divisional applications also, the filing date will be different. We'll file it later on in cases if it is required. But we are claiming the priority over the. We are seeking the date of filing of the ordinary application as the priority date. So yes. Yes, sir. Please continue.
Okay, thank you.
Yeah. Okay. So yes, for a divisional application or patent of addition applications, the filing date definitely it varies from your original application because it will be filed after the filing of complete specification. It can be done before publication or after publication also, but we are claiming the priority over the ordinary application. So the date of filing of the ordinary application will become the priority date for your patent of addition and divisional applications. And again, a term of the term of patent also for the divisional application will be 20 years from your priority date, which will be the filing date of the ordinary application. Any confusion here, guys? Or fine?
Ma'am, please repeat.
Okay, so see, today I have filed my ordinary application. Okay, maybe after the it is order application in the sense, guys, divisional and the patent of addition can be done only for complete specification. So I'm referring to complete specification. Today I have filed my complete specification. From today, 18 months, it may be published, but before publication itself, the applicant has thought, okay, my invention, if we just replace component A with component B, it can be used for different application also. So then that falls under divisional application, because we are replacing the product and the application is also different. But the entire structure, the other structure is everything. The main components which are there, we are using the same thing. We are not doing any modifications to the active or main components. But some other minor components, we are making the replacements and everything. The application itself, we can use that entire structure with a minor replacement to another different application. So that will be under the divisional application. Patent of addition comes. We are using the same components, everything same, but we are just changing the composition of components a little bit together to give a new advantage. Then that becomes a patent of addition. So these applications, we are filing it in the later scenario, but we have already a filing date for this complete specification today. So for this other applications, whatever you have filed, we'll be filing it later, maybe 18 months later or before 18 months, like, but anything which it will be filed from today. But these applications which are filed later than this 12th February 2022 will be gaining the priority of this date itself, even though they are filed later. So they will see the main thing is priority is we are considering is to your application will be a prior art for other applications which are similar to your idea. You're gaining a priority over the similar ideas which will be filed from tomorrow onwards. Similar ideas or same idea, it can be same idea, but it is filed from tomorrow onwards. Your application is going to gain the priority over the applications which are filed from tomorrow onwards. Again, maybe tomorrow application may have some other additional benefits, but you're claiming those additional benefits in this divisional application of patent of addition. But your application will be considered first because you're claiming the priority over the ordinary application which is filed today. So tomorrow someone is filing a similar application. He has some other application. He has included all applications, different varieties and everything in one document. Okay? But you're claiming those documents in divisional and patent of addition from, you may say, okay, a week later from today, from 19th February, example. But your application, you're claiming the priority over today's application. So your documents will be the prior from the documents which are filed from tomorrow, which have the same idea. So you're just gaining the priority from the original filed application, ordinary application. That's it. So this filing date and priority date, there'll be a confusion. Filing date is something on which you have filed to keep the timelines, like on which day it will get published, from which you have time period of 48 months to request for examination. So it will be all will be calculated from date of filing, that is filing date. Priority date is, it comes into the picture for divisional applications, patent of addition applications, or for the conventional applications too. So someone already filed a US application in US today, and he wants to file it tomorrow in India as a conventional application. So we are claiming the priority of that US application which is filed today for tomorrow's application in India.
Okay.
Got it?
Yes, got it, ma'am. So if I'm not wrong, like for if I'm filing a complete specification today, my priority date and filing date will be the same.
Yes, the priority date, yeah, we can say the priority date of filing date as same.
And if I am filing a provisional specification today, and after say 6 months, I am filing again a provisional specification, then finalizing it with a complete specification after 8 months.
First filing provisional date will be considered your
will be the provisional date.
Yes.
And the filing date will be varying here.
The filing date will be varied, but the term of a patent will be calculated from your first application.
Okay.
First provisional application, which will be considered as a priority date for all the complete specification and number of provisionals, whatever you're filing it, all will be claiming the priority over this first application. They're claiming this. So their date of filing will be maybe different, but you already got your application number in your hand, and the date of filing of that application number, the date of filing date of that first application will be your priority date for the consequent applications which you're filing. in relation to the first application. Okay, you're
Yes.
claiming the date, you're claiming that date, that before date you're claiming. So that is a priority date. You're giving the priority to the first application. So you're making sure that you have filed on that day only all these things.
Okay.
You'll on record it will be some different dates, but when it is published, it will be showing the date of the of the first application which is filed. That will be published. That is the only. I mean, it will be considered as a priority date if you're going with a provisional specification. And priority comes, the term priority only comes into picture when we are going with number of provisionals or number of divisional applications or number of patent of additions. It can be one or more patent of additions or one or more divisional applications. All this will be claimed priority of the first application. So we are just making sure that it is related to that application. So we are claiming that date. So that is, so we are mentioning it as a priority date. But when it comes to calculating the term of patent or the other deadlines, like publishing or filing the request of examination, is 48 months from the date of filing of the first application. Everything will be calculated from that date of filing.
Okay,
So-
even if I am filing a provisional specification, 18 months will be held from the date I am filing the provisional specification and not from the date I am filing complete specification.
No. Yes, from provisional specification itself, it will be calculated for publication.
Okay, even
saying,
the date for examination, whatever I am filing.
Everything will
examination.
be considered from the date of filing of that first application, which is your provisional specification.
Okay, okay, thank you so much, ma'am.
Even the term of patent is also calculated from that date.
Calculated from date.
So whatever divisional applications, patent of addition, even though you're filing it after 3-4 years of the first application also, you cannot claim additional 4-5 years of protection for those divisional and patent of addition.
Term will end after 20
term
years
will
from
end
the
exactly 20 years from the date of filing of your first application.
first application or
can
date
be
of priority or the priority date of any provisional.
Yes.
Okay, got it, ma'am. Thank you.
Thank you.
Ma'am, with respect to the divisional application, the applicant have the option to decide to go for a divisional application, or the controller have the power to divide the main application and suggest the applicant to divide that application, or
It can
both having the
happen.
power?
Both can do it because generally here the applicants, like, instead of we suggesting, in general practice, the controller directs us to go with divisional applications if he finds that it is really necessary. But mostly, even though the controller directs it, if the applicant feels that there is not required for number of applications together, we can provide our own arguments or our concepts to the controller. If he still feels that no, the divisional is required, then we can go according to him, which will be done during the time of providing the FER report. When we'll get the first examination report, in that scenario, the controller instructs if he wants to file divisional. Before that also, if applicant himself feels that there are number of applications, but we are using the same product or process, but we're having different number of applications, then also we can file it as a divisional application. We can file it, but before filing, we are going to request to the controller. Anyhow, we have to submit the forms for that, the divisional applications, and we have to state the cause, like why we are filing the divisional application. So we can do it.
Understand. Thanks.
Yes.
So this has to be done only after issuing of the FER or like while responding it, or we can do it before also?
Before also we can do
Okay.
it. And at the time of FER also, if the controller, at the time of FER, then it is under the instructions of controller itself. And they'll not directly say us to file it a divisional application in FER report. Generally, they will not give a direct inclusion, but they'll say that the claims are, there is a lack of unity of invention in the claims. Lack of unity of invention itself implies that we need to file a divisional application for those particular claims, a separate set of claims. We need to file a divisional application. So yeah, here, while drafting the claims also, we have to check this unity of invention and definitiveness, clarity, and everything should go for only single product and a single process. If you're claiming both process and product, they should be complement to each other. These are things. In an application, we can claim both products and a process, but they should complement to each other. The process should belong to the same product. It should not deviate from the product which we are already claiming in one independent claim. So these are some points which we need to keep in mind when we are drafting the claims. Apart from inventiveness and novelty, we have to keep this unity of invention, clarity, definitiveness. Definitiveness is thing, whatever we are claiming should also reflect in the other parts like description, summary. We have to include whatever we are doing in claiming, everything. Those technical terms should reflect in the entire document. And also unity also can come like if we are using the technical term, we shouldn't use for a same product different technical terms. We cannot use. We have to use one technical term entirely. So there should be uniformity in describing the component also. So in claims, we cannot use a higher level of some more advanced version of words in claims, and in description you are just nominally saying a process, a kind of thing. And when it comes to claims, we are giving it a very technical process. You shouldn't add different words. There should be uniformity between all the words, especially the technical terms which we are. Okay, yeah, you can change the slide actually. I'm just generally discussing it. Yes. So the next topic is, this is something which we need to do the search generally when we are drafting it. For your examination purpose, no search or kind of thing. You will be provided the information. You need to just arrange them under the sections properly, and claims you need to draft it. That is the main part which you have to take care in your drafting part. So, but in general, you have to do a proper search. Next slide, please. To get that inventive and novelty concepts, you have to differentiate your applicant's process product from already existing prior art in terms of novelty and inventive. You have to take those, you have to derive those novelty and inventiveness from. And also the patent information, we have technical and non-technical data. So technical data is your patent document. I'm saying this. Technical field, background, summary, this is all the technical data. And non-technical data is what we have discussed in now, the filing date, inventors, name of the applicants, name of the inventors, the jurisdiction, and everything falls under the non-technical data. And next slide, please. So here also, from the filing application, your application number consists of 12 digits. Our Indian application number consists of 12 digits. So the first 4 digits is the year of filing, and the next 5th digit will be your jurisdiction. So one is Delhi, 2 is Mumbai, 3 is Kolkata, 4 is Chennai. So if the application goes 2022-4, then it is accepted in Chennai office. So someone who is filing from the states of Telangana, Andhra Pradesh, Karnataka, Tamil Nadu, Kerala, and Lakshadweep Island, and everything, those all are represented by Chennai office, so one office. And next comes the other digit, 1, 2, 3 till 9. So 1 will be for your ordinary application, 2 will be for your conventional application, 3 will be for your patent, PCT application. Again, after that, we'll have again 1 to 9. So ordinary, just a complete specification will be with 0. And if we have a divisional application 1 and or patent of addition 2, so it goes on. These are all given in the manual. I'll be sharing those examples tomorrow for you for the introduction. I'll be giving some examples. So from the application itself, you can just find out at which date it is filed, and the jurisdiction will be, you can understand the jurisdiction in which office it is filed. And also coming to the technical data, I'm saying these are the fields like field of technology, background. So in your drafting, in examination, in background, you have to state like they will provide you the problem, and also they may provide the existing solutions, and they can come back to the present solution, what they're offering for the same problem. So in your background, you have to describe, you have to give that problem and the existing solutions. And what are the disadvantages or what are the issues we are facing in that existing solutions, if any? If there are no existing solutions, then it's fine. We can just state the problem and leave it. That comes under your background. But in general, once you're qualified as your patent agents and you're coming into your practice, then before drafting, you're going to conduct a patent search. So whatever the prior art which you have indicated in your search document, you can include all those patent documents in your background, as mentioning it as a prior art, and you can also differentiate that prior art in terms of what are the issues or what are the disadvantages or what are the drawbacks of those application. Those comes, because you already have something better in your hand, better product. So you can compare your present one with those prior art documents, and you can just mention, okay, this still has this drawbacks, this should be overcome and everything. That comes under your background. But for your examination, there will be no prior art. You're not going to mention any prior art kind of thing because you're not going to do any search in your exam. So only the problem statement should be mentioned. And if there are any existing solutions to that problem, which is already mentioned, only mentioned in the document, the question, then you can mention up till there. That will be your background. And abstract should be limited to only 150 words. And generally we place that abstract after the claims, the last page of the document, we place it as an abstract. But when your application is published in patent journal, the abstract will be reflected in the published paper, in the publication. It reflects only the abstract. So it should be filed in a separate paper. Actually, it should be in a new page, but it should be a last page of your document. But it should be a new page. There should be continuation kind of. And drawings to be in a separate document. And we also have many rules for the drawing also in terms of the color, the scale, how we are numbering it, and the representation of any text data in the drawing. So there are a lot of rules in there for those drawings also. We have a separate rules for that. And coming to the complete before going to complete description and before the drawings also, we have to mention the scope of your invention, which comes under the summary. The heading will be summary of invention, but there we are going to mention all different types of objectives of your invention, scope of your invention. Like what is, if we conduct some experiment, we mention our aim. Aim is to get this and this, or to study this and this. That will be your general description in your experiments, in the chemistry experiments or physics experiment. But here we have to project like the object or the scope of the invention is to provide this product which can facilitate so and so and so on. So these all are we are just giving a brief idea of your entire invention in those summary, just giving you the entire scope in a briefing manner in the summary part. Then we'll just give a brief description of the drawing. This is like we are going to give the title of the drawing, like in that paragraphs, and then we'll go into the detailed description. So in this detailed description, we have several number of embodiments. Embodiments in the case that a number of applications of the same product, or this product can be altered in many different ways, or this product can be used in multiple application, or it may not only product, the process also. If we change this step, the result can be same, but the time will be reduced. Performance is more, but the result is same. So these are different embodiments. So everything, all the different types of embodiments. But again, here also we have one preferred, the main thing which we are claiming should be our preferred embodiment. Or guys, everyone have a problem with my voice? Everyone?
It's fine, ma'am. It's fine. It looks fine.
Fine. Okay.
Yeah.
Better, ma'am. Yeah.
Okay. Yeah. So okay. Thank you, Zach. So the complete description, the detailed description, we are going to give number of embodiments and also describing each figure, whatever figure you're going to give in a separate sheet, drawings or tables, graphs, whatever it may be, you have to describe everything here. We should, and also, not every application can provide drawings for all the embodiments, but at least there should be a drawing for the main thing which we are claiming. And coming to the claims, this is the main techno-legal part. We are defining the boundaries of our application in the claims. So whatever, we have to see that we are not claiming the entire universe, but a bit of it which is unique, which is novel, and which is inventive from already existing. So we are just drawing the boundary, a legal boundary with these claims for our patent. So this is the technical part of your patent application. Next slide, please. And non-technical, I said inventor, assignee, patent number, legal status. So for inventor, he is the one who came up with the idea, who has structured that idea into a product or a process. So again, he has a right to file the application in his name itself, or if he is an employee of an organization, then the organization will be the owner of that patent, and they can be the applicant. And if there be some IPR policies for every organization, if they want, even the inventors can also be applicant along with the organization. It can happen, but it varies from case to case. Generally, not all organizations allow the inventors to be the applicants. So if case arrives where the applicant and the inventors are different, then we have to provide an assignment, a form 6. No, not form 6. I'm sorry. There is a separate assignment. There is no form 6 for this applicant. This change of applicants will be the form 6. So we have to provide a proof of right for this. So proof of right is where the inventors, all the inventors should agree that we are assigning our idea to this so and so institute. So we are assigning our complete legal rights to our organization to represent us for this application. So the owner here is the one, like the applicant is the owner who has the right to issue or to make the product, to sell the product, to import, export or import, whatever it is. He has the sole ownership of that. And also he is the one who is answerable in front of law. So he is the one who should also take care for all these legal activities which may fall upon him in terms of license agreements. If he wants to do marketing, then he is the one who will be the licensor. So who is giving the license to different applications. So he's taking care of the legal process. If there is any infringement, then the applicant himself should appear for the hearings. He is responsible for all those acts. That is a different one. And coming to legal status also, until the application is granted, the applicant can enjoy the right of patent pending status. So it will be deemed, and even he cannot claim that I applied for a patent. It is a patent application. If it is only granted, then it will turn into a patent. Before that, you have to mention it as an application, not a patent. Patent is something which is granted. If it is not granted, it will be an application itself. And the different number of legal statuses after 18 months, it will be published. So we'll say published, pending. Pending means the examination is not done. If it is already examined, again, the status will change. Examined, pending. Pending is not, did not arrive to the decision whether it is granted or discarded. So still the stage from we receive the FER report till we appear for the hearing, the status will be examined, pending. And again, once we appear for at the time of hearing, it will be like it is in a process of hearing. pending. So all these things. Once it is granted or not granted, if it's granted, we clearly mention it. This is a patent active. Active in the sense like now we are using the patent. I mean, before that also will be used, but we also have another clause like we need to submit the working of the patent every year to the government under Form 27. So active in the sense like these people are maintaining, the applicant is providing an annual fee to the government for the patent office to keep that on record, that application. So it is shown as an active. So granted active. If it is discarded, then it will be clearly shown like refused under section 15. So once it is refused, then the applicant nowhere can mention about the application now, the application or a patent pending. He cannot use those legal status anywhere for his product or process. If it is discarded, then it is discarded. That's if it, before the reason comes or before the decision is given, he can clearly use the patent pending legal status along with this application number on the product itself. If he is already started manufacturing it, he can use that patent pending and the application. So it is a clear indication that my product, I already claimed it for the patent protection. So if someone infringes that product, I mean, tries to copy or resell that product, then it is easy for the applicant to sue, to provide, give the infringement suit of, I mean, he can sue it under infringement, but again, he can collect the damages if it is granted. If it is not granted, then no, the case is dropped. So these are the different legal status which we see. And I already told there is a convention application, a PCT application, national phase application, everything. So convention application, it is a kind of individual international filing. And PCT is a single application. With that single application, they are going into multiple countries after 31 months of the first filing, in the original, I mean, filing date of the first application. So these are the different types of application. And also we have here, in terms of convention application in India. So if I want to file an application in US before filing it in India, I don't want to file it in India because I know the market may not require this product as of this moment, but in US my product can fetch me good gains kind of thing. I want to market my product ASAP in US, but so I want to file it in US. If it is the scenario with the applicant, then before going ahead with it, we have to seek permission from the patent office under Form 25, like the applicant wishes to this, and we have to state reasons so and so. And from the date of request, the patent office will take 15 days to grant the permission. And once it is granted, then he can go ahead and file it in US first. And later on, he can, if he wants to, he can go with Indian filing or not. And again, if already filed, someone US citizen, so this is the convention scene. And also another scenario is, I already explained, US application he already filed yesterday in US, and he wants to file the same application in India today. So it comes under convention application because the filing is already done in other territory, in other jurisdiction. So that comes under convention application. PCT, at the end of the 31 months from the date of filing of the original application, which we file it for the PCT application, after 31 months, it naturally comes like, now it falls under the national phase application. From there again, it will already published in under PCT portal. So now examination, everything follows. After it enters into the national phase, automatically it goes with the examination and other process, which we go with ordinary filing. So this is the data, guys. Next slide, please.
Here I have one doubt here.
Yes.
Suppose if the inventor are from the other than India, the foreign people, and the applicant is originated from India. In this case, still we need to take the FEL from the Indian Patent Office?
No, because applicant is already the resident of India. Applicant can be a company or it can be an individual, but he has his communication for service address will be in India. So it automatically comes under Indian jurisdiction. So
No. The inventors are from the foreign.
There is no problem with inventors. It's only the applicant. So the ownership matters here. So if the applicant is a foreign startup or a foreign MSME, if he wants to file it in India, again, but see, applicants can, I mean, inventors can be Indians, but the applicant is of some foreign jurisdiction. So he's filing through some patent agent, right? If he's going with the direct filing kind of thing, then he need to provide some address of communication in India if he wants to file it directly. If he goes through patent agent, then the address of communication of that patent agent will reflect, and the jurisdiction will automatically be defined upon the address of that patent agent in India.
Okay.
So it is not like, yeah, the scenario comes like most of the recently, especially from UK and kind of thing, I'm seeing it, they're filing directly in India before filing it in UK or US. So they need an address of communication of Indian. So they are going with the patent agent address.
Okay.
So the jurisdiction will be decided in that way. And it can be considered as ordinary application because it is nowhere filed before anyway. They're directly filing it in India for the first time. So it will be considered as ordinary because the address of communication will be reflected here.
Understood.
Yeah. Anything, guys? Yeah, so why patent information is important. So I already told, like, we need to find out the date of filing, that year of filing, to see the prior art. So what is considered as a prior art? So today of filing it, anything which is filed before today, like till yesterday, everything will be considered as prior art for your application in the same domain. So, and in India, generally after publication itself, all this non-technical, like the application number, the abstract, the name of the inventors, the assignee, everything will be, it can be clearly seen in the public domain after the publication, after the 18 months. And now we also have the provision of early publication. So once you file the request of early publication of the Form 9, it will be done within 21 working days, 15 to 21 working days, it will be published. So this can be done before 18 months itself. But again, the publication, early publication can be requested only if you file complete specification. If only the complete specification is filed, then only you can request early publication. Next, yes. So patent search. I'll go briefly like why patent search is important and everything. So there are several reasons why the patent search can be conducted, and patent search is conducted before filing and after filing. Also, there are different kinds of search that. So one thing is the prior art or the prior search, which if it is in the stage of idea, let us assume you have an idea. You are confident that that idea can be implemented to a product or a process, but you're still in a confusion, like, okay, this is an idea, we need this so and so components to get that product or process. Before filing in a patent application, you can do a quick prior art search in the same domain, which is, I mean, you'll have number of patent applications from all over the world, around the globe, the patent, and you can just check it. Okay, my invention, my idea is there, but you may not know it is already filed somewhere else. So you can get, after seeing those applications, you may see number of embodiments or number of alternatives which you have seen, and you can also go for further research from those ideas instead of just giving a struck upon, okay, this is an idea. Maybe you may have many advanced versions also which are already filed or which are already working in those countries, because we don't know what's going all around the world, but every company, what they are manufacturing and everything around the world. So this patent information is something which can help us to avoid reinventing the thing, same thing. And coming to similar applicant idea is there, then you can go ahead to research further on that. If you already find a similar thing, why to again patent the same thing? Anyway, in FER, in the terms of examination, even the examiners to conduct the search. During the examination, they give a thorough check through the database. They go, we'll get list of prior arts, list of applications. And if you go through them, then we can see the similarities. Like They may name the technical terms different, but the purpose of it will be the same. So they say, okay, now they're using the same thing. Show me your inventive step here. So there we might face an issue of proving our inventive step when we compare it to the similar things, which are almost like 98% similar, then those kind of things will be given in the PR. And coming, so to make our product more unique in the sense of novelty and inventive over the existing one, it is best to conduct a search before applying for a patent. Next slide, guys. Brijesh, next slide, please. Yes. Yeah, so how it is really useful, wealth of invention, avoiding reinventing. We can also avoid the cost in R&D. So to whatever you want to develop a product or a process, if it is already existing somewhere, you're instead of wasting the resources kind of thing, if you conduct a prior search before developing your idea into a product, you may cut those costs. And also foreign direct investments, technology transfer, corporate strategy, these are all some things. These are the things which comes after the filing or after the grant or something, when you're already marketing your idea kind of thing. Then this foreign direct investments and technology transfer, corporate strategy, these three falls after. Before filing, the first three falls. After filing, the last. Those are the some things where it involves the licensing, or the thing is, it may see it, if an individual is filing, he may not have the capacity. Generally, an individual can be a student or a general employee or someone who is an individual who doesn't have any startup or company or kind of thing, but he has an idea, a very good idea, which is already patented, which we have filed for the application, which is still in the grant, or if it is granted also. But what is the use if that product is not brought into the market? So to get that into the market, then definitely the individual should go for the licensing terms, or even he can assign his complete rights to them, like transferring his ownership to someone else, that is assignment. So all these things, if it is already done by a startup, they have the capacity, but they still lack some kind of resources, then they can go for investments from other companies or from other states or from other countries. So those comes under foreign direct investments. And technology transfer is something, an agreement between, especially between the educational institutes and the industrial organization. So this is an agreement between these two entities. And nowadays also we can see these academic institutes are really active players in filing the applications along with corporate people. So they are on par with them. So again, the academic institutes is only for the education purpose. They cannot have a business side, or they cannot, there is no money involved, like in the terms of like they cannot do a business education institute, but they can transfer their entire patenting idea or whatever the IPs, whatever they have it, to the industrials. They can just transfer it. It can involve license, or it can involve assignment. It depends upon the IPR process from organization to organization. This what are the two parties in technology? That is education institutes and the corporates. So these the corporate strategies I told, it can involve the number of licensing or assignments, all comes under. So whatever it is completely based on your patent information. So always having a good data on your patent before filing and after filing is also. After filing also, we have number of strategies. Not only in India, we have pre-grant and post-grant. Especially in India, we have grant opposition before granting and after granting. So this is something which comes after filing. So there also, for those oppositions to counteract with this opposition kind of thing, there also again we have to go for a proper search and everything. So always having a good amount of patent information with the applicant or with the agent is always, I mean, it is really considered a good strategy to avoid any further conflicts at the time of examination or after the examination or before examination, because we have pre-grant opposition facility in India. Others they don't have these two types of opposition. They have only one kind, but in India we have the next slide. Yeah, I think you can skip these slides because I already explained it. And if you want, I mean, the guys, they can share my presentation. So what are the information where we can do it is mainly USPTO, EPO, that eSpace for the European patent database, that is really good. And also the WIPO database, that is a patent scope, that is also good. That is also a global database. But each database has a different version of, I mean, the amount of data covered or the number of countries or jurisdictions covered varies from database to database. And Google and the eSpaceNet are on par because they're also including the Asian countries database also nowadays. So they have a good amount of information as of now. And USPTO is mostly of US applications. It is entirely the jurisdiction, and Indian database is also considered only for Indian applications. So it also involves the PCT, but it is whatever it is filed in India, we'll find it in our database in India. And also we have many paid databases and non-paid also. We have some free databases, and apart from patent document, guys, we'll also have a non-patent literature where it includes the research papers or some articles or whatever the chapters in the textbook, I mean, in the book which we are publishing, everything. Those are also can be, they are considered as prior art, and they can also be reflected in FER during the time of examination. The controller directly can, because we'll see, I'll give you an example. There is a, nowadays we are getting during the Ganesh idols, during Chavati, they're sprouting into the plants. So they are just using some seeds in the idol. So when we just immerse it in the water, they get soaked up and get into the plant kind of thing. So this is a general idea. And we find many, I mean, few patents are already registered on that. But before that, this idea is already published in newspaper articles, and they're already actively in some, maybe not on wide scale, but at least on a small scale, they already started marketing. So for that kind of also, these newspaper articles are considered as prior art for the patent applications. So this non-patent literature, I'm saying this is a general example. Even the newspaper articles are also considered as non-patent literature, and they can be given as the deviations in our examination report, during examination report. So not only searching for the patent databases, sometimes when we conduct a lot of search also, we may not find a relevant data for the idea. So we have to be sure that whether maybe they may not be patented properly, the exact idea, but they must have already represented it in terms of any research paper kind of thing. So it's better to check in there in such databases also. So we have a Google database for the non-patent literature directly. We can get it, or we can have for the lens. So these are some names of the databases which are available freely for us. So this is the where the information is available. Next slide, guys. I think it's over. No, go before. So yeah, the information search I told before filing and after filing also. So before filing, we have few searches, that is a prior art search and a state of prior art or state of art search and patentability search. Prior art, it covers a broader prospect where the inventor still is in the idea stage and he's not into a complete product or a process stage. So it will be given in a broader perspective. The search analysis, it will be in a broader perspective. When it comes to the patentability search, it means that the applicant is ready with his product. He knows, I mean, he has given a sufficient amount of information for us. So with those different components or whatever the number of steps involved, different steps, all these things, we can compare it with the claims of the relevant prior art, whatever it is there. So in state of report also, we have two sections, related and relevant prior art. So related is maybe the idea, I mean, the domain in which the working is similar, but whatever the result may not be same. The product is used, but the result may not be same. That is the related. Relevant is something, the result is almost similar, and whatever the components, everything are used are also similar. So relevancy is something which is more completely reflecting your present applicant's idea, which is already reflecting in the prior art, which are already filed. So these two. So state of art is something a broader search, but patentability search, we are narrowing down our search to a particular components and steps. And after filing, we have invalidity and freedom to operate search. So invalidity search, it only involves one patent document, and we have to invalidate each claim with the search. And freedom to operate is kind of thing is, it is a kind of thing where we are not related to one, especially to a patent document. A patent document and also a product. And we have to invalidate, I mean, we have to check if whether we are free to market that product in such certain jurisdiction. So it depends upon the jurisdiction, freedom to operate. So the client has already filed an application, or he is ready with the product, and he wants from India. So now he wants to market that product in US. So now we have to conduct a freedom to operate with the US database only with the active patents, means which are active, which are not expired. I mean, the time limit is still within the 20 years from the term of patent, that is an active status. And we have to compare the main components or the proper technical aspects of this one with the claims, especially with all the claims. So there should be a claim mapping thing. So in this invalidity and freedom to operate search, will be concentrating mainly on claims, only on claims, invalidating the claims and everything, and also the legal status of that, whether it is assigned or licensed, or is there any infringement things going on, it is still active or not. If it is expired, then there is no issue. If that application is expired, then he is free to go and market his product in that jurisdiction. If it is active, then we have to check how much it is matching with that scenario. If it is entirely matching, then he cannot market it. If there is some minority differences, then he can market it. And there is also another strategy. If he wants, he can file it, or he can directly market over there. Those are the two things. Next slide, guys. Yeah, this is the explanation. So clearance search also comes for the, it is also termed as the freedom to operate search. So this mainly depends upon the, if freedom to operate is only for the jurisdiction. If he wants to do it in US, then we have to consider only the US applications over there, which are active. So patentability in searches, before we file an application, we need to do that patentability search to come to differentiate our novelty and inventive of the present application. The state of art is, it is a broader thing to provide the applicant with various number of applications, various ideas, various solutions to that problem, number of alternative embodiments, so he can narrow down his research work or his whatever develop product to a particular scope. Like, okay, in my product, only this one is new, which is not matched with anything. So now what is the new? Only that we are going to play. Not everything, only that part we are going to play. That's it, guys. Next slide. So why is connecting search is, we have to do it a search to draft a proper claims. So in claims, the main independent claim should show the inventive and novelty aspects. So those two should reflect in our independent claim. That is the first main claim. And we can have more than one independent claim in our Indian jurisdiction. It's not an issue. There is no limitation with number of independent claims, but overall number is also not restricted, but we have to pay additional fee after 10. If it exceeds 10, then we have to pay an additional fee, but there is no restriction to the count. Like we have to have this number of independent and this number of dependent claims. But in US, for each application, they have considered only 5 independent claims and number of dependent claims they have not restricted. But in India, we don't have such thing. But again, we have to consider if we are giving more than one independent claim, then we have to see there is a unity between each independent claim, that it is not deviating and it should all reflect only one product or one process. It should not deviate from that. So when we cannot claim more than one product or one process in one single patent application. I think that's it. Vijesh, is this the last slide? Yeah, that's it. Any doubts, guys? You want to discuss something or you want to ask anything from this topic? It's fine. Or do you want me to provide any more further information also? You can let me know if I can discuss it. I'll discuss it now, or I can include those topics in our tomorrow discussion.
Madam, I have a question, madam.
Yes, sir, tell me.
Prior to drafting the specifications and claims,
Yes.
patent search is made. Patent search is made. Patent search.
Yeah, patent search will be conducted by, we have to conduct it. And even if the applicant already conducts, he can provide that prior art data for us. But in claims, we are not going to mention any prior art. Only in claims, we are going to concentrate only on our present product or process and the inventive and the novelty concepts of the product and process in the first main claim. So we have to.
Can we offload the task of patent search to someone?
Yeah, yes, they are. Okay, after, you mean at the time of drafting, I mean, in general, you're saying not from the exam. Yeah, there are separate people, like we have patent analysts or IP analysts, you can say. Those are a group of people who conduct these kinds of searches, and they have a proper market analysis. These patent analysts and IP analysts are a team of people who conduct this kind of searches, like whatever I say, freedom to operate and everything. They are mainly involved in that, and they also have a good market analysis also. So they can easily market. They can provide us a good data on the present market scenario also. So it can be conducted by someone else also, and we can request such prior art data for us. So for main thing is for us to draft, I mean, we cannot completely rely on applicant's data. See, if say, okay, I have got this in constitution and this, we cannot directly draft it. Okay, this is present, because we are going to go for an examination where the examiner sees this novelty and inventiveness. So unless we conduct a search, we cannot come or we cannot derive the novelty and inventiveness. The client or the applicant says, okay, it is my idea, this is new, and this for him as an individual, he feels it is inventive, it is novel. Okay, that's good. But there is always parallel thinking. There will be number of applications, similar things which is already filed. So we have to make sure that our thing is it is above all the filed applications. So to bring those inventiveness and the novelty, to derive those concepts itself, for that research is a good strategy to do. If we don't conduct a search and if we go for a drafting, that's also in most scenarios it is done. But at the time of FER reply, there again, we have to search our own inventiveness and novelty concept. There we have to derive at that point of time. If suppose we were unable to prove that in the document, we cannot add something new at the time of FER. So it will go beyond the scope. So because we already defined a set of claims, but in reality, if we compare at the time of FER and we think, oh my God, okay, my invention can also work in this scenario also. If applicant says at that time, then no, we cannot add that things in at the time of FCR because it goes beyond the scope, because we already defined a boundary in the claims. So it is a good strategy to do it at before the drafting itself. Before drafting claims, it's good to conduct a search.
Madam, we conduct a patent search, and when we conduct, we found that inventive step and novelty is satisfied. Okay, but when it goes for examination, they still conduct patent search.
Yes.
There is some problem.
Yeah, they can come with number of things, but we are sure about our inventive and novelty in our claim one. So we can compare with the claims, and we can still produce our arguments only with those particular concepts, not the entire thing. And if possible, if at the time of drafting, we may keep our independent claim a bit broader scope. We don't narrow it. Generally, we don't narrow it down. We put it in a broader scope, and we narrow it down in the dependent claims, completely narrowing it down. So at the time of examination, if the controller feels that, okay, you have given a broader thing in the claim one, and from claim 2 to 5, which is depending on claim one, they're narrowing it down. And he may ask us, okay, what exactly are you practicing from 2 to 5? And if we say, and he may ask, which is the best from 2 to 5? If we point out something is best from 2 to 5, then he asks us to narrow down the first claim for that particular component. So let me give you one example. So in a chemical, in some processing method, there is a temperature. So for any processing or manufacturing method, we consider the temperature, pressure constraints, and what are the equipment used, and especially we go with the chemicals. If it is a chemical, then we go with the temperature resistance, temperature, like all the categories we need to include in that. Now comes in the main claim, I claim that it is carried at the room temperature. That is the broadest prospect, I have to say. But in reality, I'm narrowing down the temperature into certain range, or say room temperature. If my experiment can be conducted, or my method, my process works best from 80 to 100 degrees. That is the claim one. But in reality, it performs well at the temperature from 87 to 96. That is the exact range. But I'm broadening, I'm extending the range in the claim one. But in the claim 2, 3, 4, I'm giving the ranges, narrowing it down, down, down. Now the examiner says in the prior art, in the FER, if he comes to the FER, he says that, okay, the same temperature, whatever this 80, 100, which we have given in the claim one, it is already claimed in the other prior art. Then we can say, okay, we have broadened them, but in actuality, my thing gives a perfect results from this 85 to 96 temperature. This gives a perfect result, but this 86, 95 is in the dependent claim. Okay, we are narrowing down dependent claims, but mostly the examiners consider the first claim itself, so the independent claims. So we can say, sir, okay, I'm narrowing down. We can say, okay, the D1, D2 has given to 80 to 100, but my thing works best at this temperature, which we already claimed in this. So then the examiner asks, okay, yours is inventive, but please include this temperature, change the temperature and include that. So then automatically, we are just narrowing down the temperature constant in the main claim to overcome that inventive step during at that time. So generally, it's in general practice in the claims, first independent claims, we keep it in a broader perspective to avoid any related arts in the near thing. But in the worst scenario in FER, if such kind of things are already proved, then we have plan B with the dependent claims where we do a good things. So always remember, when there is a range coming in between this range, so give a broader range in the main claim and narrow it down to the exact ranges in multiple claims. If there is no such kind of art in the FER, then we are just have increased our boundary our scope of protection for the invention a little bit. In actuality, it may be different, but we have just broadened our scope. So, also sometimes if we conduct a proper search, whatever the deviations were, the prior art which is given in the FVR may also reflect whatever we have conducted in the search time. So during the search also, we must have arrived, okay, this must be the differences, or it may be similar also, we must have arrived, okay, even though it is similar, this process takes this much time, or it is very complicated kind of thing. So such kind of arguments or our objection, our arguments to the objections, we can give it. So if we have done a good search before, then during the FVR, we'll not have this much effort. But without a proper search, if we go for a drafting and at the time of FVR, then we have to make sure that we are not going beyond the described scope. We shouldn't cross that boundary, and we have to prove our point only within that boundary. If we try to just include any additional thing also, it is considered beyond out of scope. And there are many chances that the controller will object to such kind of additions, and he may not determine the grant for that.
Before drafting the specification, we should ask why, how, when. All these things should be.
That is the proper invention disclosure, I'm saying. Exactly. So we have to also ask the inventor if there are any alternative methods also, and why, how, when. Why means what is the necessity for a product. So he'll definitely say this is the problem existing, and for that my product is a solution. So why is done? What? So why is already satisfied over here. So why is the problem, and that is the solution he's offering. That is why is satisfied. What? So what is a product? What are the components? So there should be a proper sufficient amount of explanation for each component in terms of the technical aspect. Is in if you go for a normal mechanical locker kind of thing, and we are saying number of digital pins are there and kind of thing. So now we have to say how these pins are functioning in a sequential order, or if it is a sequential lock, or it's not like that, it is a fingerprint, then they will have number of fingerprint sensors. So what are the different types of sensors available in the market, and what you are using, and why you are using only such thing in your product. So to make my product more compact, I'm using this kind of sensors. So these are the explanations. So okay, why you're using that. So what, how, what, why it's considered. When is the thing is where it is applied, or kind of thing, or when is not, where you can say where is thing, where it is applied, it comes under the industrial applicability. So you can also give a good number of lists. Now you can list different types of applications or uses or advantages, everything in your application. But we have to make sure that it is the claim parts are drafted in a way using certain certain terms which I come during the claim drafting. So there is a lot of difference between the patent drafting, which is done by a normal individual, and with a patent agent. So there's a lot of difference. So
if you have a time, I have a question, small question.
Yes, sir, go ahead.
Ma'am, so this is regarding say Indian application and US patent references. So in the drafting, we actually has to describe the prior art. So in the prior art, is it good to use US patents to say that this is the prior art based on which I have an inventive step and I'm filing this application? Is that advisable? That first question.
Really good.
Secondly, so secondly, if suppose we do that, tomorrow if the patentability question comes, like, okay, it is an Indian application, but if we see that based on your US reference, there's one more US patent application, therefore your patent is not patentable. So is it advisable to use US references in that case for non-patentability issues?
While connecting the e-patent search, we come across multiple things, and we will just screen down or narrow it down to certain number. Because in patent applications, there'll be a similar idea, a similar concept, but multiple applications are filed. Okay. So, and also, even though each application can be unique, may not be unique. It only proves in the term of claims. So if we
Okay.
go through the claims, if we find there is something, our product is having something different from this, definitely we can use that hierarchy in our
Okay.
background. So if we find only difference, if we don't find any different kind of thing, it is similar thing in the terms of claims or kind of thing, then it's better not to use that drafting.
Okay.
And
Okay.
we can ask the applicant to provide more information for us. If he's
Okay.
unable to, at the time, if he's unable to provide, but he's
Hmm.
still adamant to go ahead with the patent application filing of thing, then we
Okay.
have to narrow it down further, like giving it more, like I told you, the temperature thing. Every
Okay.
applicant will never disclose the exact temperature. Yeah, even I'm saying it will be done from 86 to 95 degrees, but
Mhm.
in reality, at one temperature it is performed well. No applicant will disclose, and even as a patent agent also, we shouldn't force them to give an exact thing, because that is a kind of trade secret for them. If
Okay,
they have
okay.
patent application. So we can use it a time of range. We cannot
Okay.
give an exact thing. Never a single number can be given in a range. We have to always prove it in a is to between this, not between.
Question, madam.
Okay.
So this is
Ma'am,
a kind of thing. But yes, sir.
ma'am, with respect to the examination point of view, already the technical information is given in the exam. So did you share any some best practices or the framework to come out the decent claim with respect to the examination point of view? Could you share something about the best practice which you followed or the framework to come out the decent claim?
See, in the examination, now if we go through the already question papers, you can just read the questions. You can easily classify them, which can be under summary or which can be which is exactly describing the product. So once you get that information, I mean the paragraph or the lines which is describing the exact product, then please in that you can check it what are the components and everything, and based on that lines or information itself you can claim it. And examination they'll ask you to claim only one independent claim as of now, because in question paper there is a limited amount of information which will be given. The question will be around 1 page length, that's it. But in general, our patent documents will be more than 20 pages. But here, the question will be only about 1 page. From that 1 page only, you need to define, okay, this paragraph or this part of line is talking about the problem. Okay, this problem, I have to notify it in the paragraph. Coming to the claims is your own work. So that claim part, how to draft, I'm going to give you I will explain to you how you can draft it, and even I can just give it to you how to solve the question papers also in our exercise sessions, like how generally I have done during my examination. I can give it like how I sorted it out and how did I draft it. But in examination, as of the patent examination, they will only expect one independent claim and one independent or two dependent, depending upon the amount of information they have given. So the question also, they will never give you, it will not be like a proper drafted research paper or where they're giving a good amount of introduction and all the details. Never, it will be like a jumbled thing. You have to identify it.
Madam, one question, madam.
Yes, sir.
During patent search, we know only English. There may be languages like.
So we have a good, all the database at present, everything is translated in English or a local language, especially in eSpace and WIPE Patent Scope. Even in Google also, we have the translation version, everything at present. Every database is providing English version. Or even for the French people and everything, they can go with their religion. So it is providing at least 10 different languages, translation there itself, and we can compare it. It's not an issue. We are fine with all.
Ma'am, I had one question.
Yes.
If we are talking about an inventive step, like drafting with respect to inventive step should involve technical advance?
Yes.
Or it can include economic significance or both. Have you come across any example or patent application where they have just focused on the economic?
Economic significance can be done in the dependent claim, not in the main claim. So the economic significance always comes as a dependent. So it is not only the technical advancement can be claimed in the claim one. If there is no technical advancement, but there are many number of economic advantages kind of thing, we can broaden the first claim and we can go with the narrowing terms in the terms of explaining the different economic benefits in the dependent claim. If
Okay.
suppose we are unable to cross it down, because see, not every application we cannot, at the time of drafting, we cannot strike on the inventive step. Novelty, we can prove it clearly, easily we can. Even without novelty, it's really a risky thing to go with the filing. It all depends upon the applicant. Our job is to make sure that we are at a place where we are proving the novelty and inventive concept from the information, whatever the client has provided at the time of drafting. So if it is not done, okay, our job is to derive those things, whatever from the information they has provided. If suppose not done, then we can ask them. If still they are unable to provide it, then we have to keep our claim in a broader perspective, and we can just narrow it down like in a general practice. If he says, okay, this is can be also altered in this way, in this way, in this way, then comes in the dependent claims. So
Okay.
in general, in practice, I'm saying that it is different.
So maybe during hearing or something, we can give justifications that this is economically significant.
Yeah, and yes,
So
we
kindly
have
grant this.
yes,
Oh.
at multiple stages, we have a thing where we can prove our point at the time of giving a FER reply, and also nowadays we are giving a subsequent examination report also before hearing. So they're giving a second chance for us to prove a point. If still they are not satisfied with that also, then they are even calling us for the hearing. And the hearing is the last stage where we have to prove a point. If not, and never say to your applicants again, like, you will get this, never, but you have to say we can try, but never say I will get this, I can do this.
Madam, how far is a patent agent accountable?
Why he would be accountable?
Accountable, like, can you say in which terms, sir, you're saying? Like how it is beneficial, like would you advise for everyone to do patent or not?
See, suppose an inventor comes to you and you feel that inventor, if you file, will not go through. Still the inventor insists. What the patent agent should do?
See, we should be well versed with our we have to check it doesn't never falls under section 3 and 4. That's our first criteria. If it falls, then we have to clearly explain to them that we have a clear law stating this is not allowable. Still he assists, then we have to bring the technical aspects if possible. If still not possible, then we have to clearly state that, okay, we will try, but during law it cannot be done, but we will give a try. So it goes aftermath, but never ever say that this can be done, this will be done, I can do it, or I cannot do it, we will try. That's it. And we can also not give a, like I have seen many saying like, is there any, they'll ask like how much percent of chances is available, like applicable for this application to get grant kind of. They'll ask like 50-50 chances at least, then go ahead. So they'll like, now see, the patent is the term like which is at this moment it is driving the industrial economy. So this guy, he already has a patent application, then he has the authority to gain more from which is not applied for the patent, the product which is not applied for the patent. So this is some kind of term now which is getting more monetary benefits. So for at least for that purpose, they want to go ahead with the patent filing. So, and also we have another thing, even the licensing and everything, they can be done before grant also. Before grant also, their idea can be licensed by the other applications. So that depends upon the corporate people. If they find, okay, it has a good strength, or okay, come on, whatever, if it can be get patent or not patent, maybe I can use this for my application to make my work better. So they can license it before getting grant. So once you're filed, you're free. Once you file your complete application, the applicant can immediately start with marketing and licensing and everything, because he already filed a patent and he's enjoying the legal status of patent pending. So for that type of legal status, there are many applicants. Most of them are filed, and it's our duty to get, as a patent agent, we have to at least try to get the novelty concept. Inventive step, it's really a difficult task. Like, we have to conduct a real proper search to get that inventive step, but we will get it. Most 80% of the cases, we can easily go on with inventive step. If we do it a proper search, we can easily get it. In 80% of the cases, we can easily derive by our whatever the technical advance. Like, we as an agent, we have a technical particular domain which we are more well versed. So when we do go for the patent information search in the terms of different patent documents which are already published or which are already granted, or some products which are already in the market, which we may have an idea. Okay, so I think there is some kind of similar product in the market, so we can do that market search also. And like, he asked us like who they can be. We can ask separate people to conduct the patent. So yes, we can work with a separate team who can provide a good analysis for us to do it. So it all depends upon the type of applicant we are getting. So how much he is willing to cooperate with us, how much he's willing to provide us the proper information for us. So if at the time it is not possible, then how much ever he has given, we have to keep a good, safe boundary for us in a first claim.
How much does the patent agent charges his client based on the time taken for drafting, filing, and then appearing controller for hearing? So all these things will account for time factor. So what is how the charges and payment for patent agent?
That we cannot say. So it depends upon the case to case. It depends upon our experience.
Ma'am, just one question. Just a continuation to what you said, right? So based on the prior arts that we have in hand after the search, can we evaluate the IP that we have in hand?
Yeah, yes, we can do it. Yes, definitely. Without filing the patent, also we can evaluate our idea, like how much it is worth, depending upon the search results which we have gained. We can easily check if the product is viable in the market, because see, when there is an advanced product in the market, you cannot blindly go and give some which is a normal product.
Yep.
Yeah, and we should be really frank or honest with the applicants. Like, we should never clearly say it is not possible under this because of this is the reason. If we have a definite reason, then we have to say no. If there is a chance, then we can say, okay, let me conduct search kind of thing. If the applicant is willing, then that's good. If you say don't conduct any search, do filing, and then you say that it's a risky thing and there are less number of chances to get the grant. If you really want me to go ahead, then we go ahead. And nowhere the applicant can blame a patent agent whether it is rejected or denied, because that facility we have in Form 26. So we are not held responsible for the grant or not grant. Nowhere the patent agent is done. He's only just representing the applicant. And everything, whatever, whether it is granted or not, it is the discretion of the controller itself. It depends upon the case to case also. And most cases, I have seen 2 cases where they got rejected because they have provided some additional information at the time of hearing an FER, still insisting it is under the scope, but the examiner felt it is beyond the scope and rejected the application.
Yeah. Thanks for that. So just to add an addition to that, so like we have accelerated examination for which we give the patentability search report in US, right? So in the same way, do we have to submit our accelerated report for the expedited examination in India also?
Accelerated report.
Under Form 18A, when we are submitting for expedite examination, right?
Yes.
Do we have to do we have to provide them patentability report, or without that also can be?
No. The examiner will never ask whether we conducted a search before, and he'll never question in the hearing also. He will
Okay.
just provide do you have seen the FER report anytime? Like, did you see how the Indian patent report, examination report be?
No, not at least I didn't show.
Okay. Tomorrow I'll share, because I have to hide some details. I cannot share the applicant details for you. So tomorrow
Sure.
I'll hide all those details and show how the FER report, exactly the examination report be, and what are the different deviations, how they will highlight it, and what are the different types of objections we'll be getting. And we also get objections in terms of the forms which we file. So there'll be some literary formal requirements. If we don't file certain forms within the time frame which was described under the rules section, rules 2003, now it is 2020. So whatever those type of objections also, even there are cases where the application got rejected because of formal requirements, I mean insufficiency of formal requirements. So we have to all those. Yeah, there are a lot. I mean, there are few cases in that way also, and even at sometimes now controller may get confused with some of the applications he considered as some mathematical formula or kind of thing. He may get confused, but we have to make sure that there is some technical aspect for that mathematical form. We are using that in that product to get this performance. So we have, because we are using this only, the product is functioning that way. So we are claiming for this. So it's bringing some technical aspect. We are not just claiming this is the formula, please provide me the patent. No, we are using this formula for this product. So the performance has increased in so and so level. So without this, there is no there is increase in performance, or there is no better performance. So that's why we are claiming this. So what is new in this product to get this result? My mathematical formula.
Yes. Thanks.
We are characterizing it, like we are just defining it the purpose. So there are some few words in the claims which you must have already come across. So comprising of, consisting, characterized by. So mostly I can also say that our type of examination is almost 95% similar to the European examination standards. So whatever those European territories, however they do the examination, similar type of examination pattern is followed in our India. In India, it is similar. If we see those European examination reports, and here if we compare it, the type of objections they raise in terms of novelty or inventiveness, it matches almost. So our law is good. I mean, it is 95% matched with those IP laws in Europe.
Yes, ma'am. Thanks.
Tomorrow I'll show you. So tomorrow I have to give you the FER report. So if you people want any further information also, you can drop me. I can prepare material for that. If not, tomorrow we can ask Brijesh to increase the number of classes, and I can cover up those topics also for you.
Oh.
But tomorrow also there will be an introduction. So I'll be just going into further details of only 1 hour, not tomorrow. So I'll be just going further more details of general introduction of. If you want me to share some of how the search is conducted, if you want me to show also, I can do it. If not, we'll just purely concentrate on examination. I can show you a number of FER reports, how it is done, and how the hearing notice also will be there. I can show you what type of objections will be coming.
Ma'am, nowadays that artificial intelligence is like in boom, we can see. And like artificial intelligence is mainly based on the softwares, and softwares may or may not be based on mathematical formula or equations, So like I don't understand like how to connect between the technical aspect of that invention and these two things, because maybe there might be some objections related to that mathematical equation or
Definitely.
computer program per se. So like
whatever this artificial intelligence, machine learning, and even the blockchain technology, whatever the patents they are getting filed at the time of examination, only one type of objection, that is inventive step. There'll be no novelty concept or kind of thing, because for every application will be having different types of inputs and outputs. So there is no novelty problem for them, only the inventive thing. So now coming to the inventive step, whatever the algorithms which we are having it in the public domain. So it is available publicly in domain, and you can say it is in a type of a share alike copyrights for the software, which is easily shared or which can be easily implemented for us. So that type of license are there for those type of applications which are already developed by people, by the companies. So now to claim a patent over those, no, you cannot claim for that application. Never for that algorithm. They'll not grant it. I said, so if you're using that algorithm for your application in your product, existing product, or for that existing product, you're adding multiple sensors for them to take the inputs, and artificial intelligence is something which is deriving a proper decision for us. So we are providing several number of inputs by us. So those several number of inputs, we are giving it through some hardware things like sensors or like cameras, or directly we are giving a data to the system. And this is also having some historical training data. This artificial data is having whatever we store it, or whatever decision today, it has derived 100 decisions. So these 100 decisions will be a historical or training data for tomorrow. So it will be increased. So it will be comparing all these things, and it comes to a decision. This is a general thing. This is a generalized version of artificial. So this is a broader thing, and we cannot claim anything over here. Now comes again, if the researcher is doing some point of changing in the way how the training data is used in different steps, then that can be claimed. So I came across one application, say the training data, generally they'll use it at the time of deriving a conclusion. But I'm using it, the training data, at the time of taking the inputs, filtering the inputs itself. I'm using the historical data and comparing it and all those things. Then he has increased another step to get a more appropriate, and he has increased the accuracy of result also because of inclusion of that step. Definitely, now he can claim for that.
Okay.
Apart from generalization, yes.
Ma'am, could you please show us any patent like in upcoming sessions, like how to draft such kind of? We should get some idea about this, because
yes. I'll give you, but I have to just hide some details for that, so I can just samples for you how the claims are drafted for those applications, and I can share at the end of the presentation also some sources, because we have a few people who are morely concentrated on this artificial intelligence, how they're practicing, especially in European jurisdictions. A few people are there who are constantly giving us the decisions, how they have overcome the inventive step for this application which uses artificial intelligence, how they have overcome. So there are a lot of sources, how the case studies are there. But here in India, I have seen the examination reports, how the European people and US people are giving. They're clearly citing the case laws. Freely they can cite it. But in India, 90% of the agents won't do that. They will never cite the case laws at all. And they will just stick to our own application. They'll never compare to the before case laws or judgments or kind of thing. They'll only just go with our own thing. And but I've seen 3D Novartis case is used mostly in all the pharmaceutical patents, because that is to prove their efficacy, enhanced efficacy point. They'll be using that same case law again and again in each FER report, which is reflecting the pharmaceutical, any pharmaceutical medicine. I have seen it. But again, if you go through the hearing thing now, they will clearly pinpoint, like to prove the point exactly in terms of numerical data kind of thing, they will ask. At least at that time, the applicant need us to provide such information to go. And also I can clearly say, like, during the time of FER reply and kind or hearing, we can provide this kind of survey analysis or your product comparative analysis with other products which is already in the market. We can prove to them, because they'll say like, okay, anyone can, during the drafting, we can say, okay, my product does this, this is the advantage, this is the advantage. We can write number of advantages. Controller may not be satisfied with the list of advantages, and he may ask us to provide at least some data, because in the worst case scenario, when we are unable to prove it, when we are unable to really prove the inventive concept, then he might ask us to provide some data, statistical data, where we can show the enhanced performance and everything. If we are able to prove in that case, then this clear, we can go with.
So that means whatever objections or whatever patent prior art the examiner has provided to us, he will be focusing on that only. He won't go beyond that.
No, whatever the deviations, I mean, we call it as deviations, D1, D2, D3, number of things, and it includes patent and non-patent. That are clearly told. They even list the newspaper articles also. So during the hearing and FER, only they will concentrate on those deviations which they have listed. And we should also concentrate only on those.
Only on that, rather than just proving our point.
Yes. And also, we should never give an additional information which we already given in the background, because most of the times, even though they read our background, where we have proved some prior art also, they give us another list of prior art. So we have to stick only to the prior art, and we shouldn't again use the background, whatever prior art which we have used, never use them again in the at the time of hearing or FER. Whatever you have drafted in the start. Yes, we are showing it to the controller that these are already existing. These patent applications are already existing. Okay, and we are saying that these have certain limitations, and we are trying to overcome that limitations with the present invention. That's it.
Yes, and very close ones, whatever, we should not be mentioning that.
Yes, yes. We have to only stick around whatever he has given, around only that we have to frame our arguments. And if possible, it's really good if we provide some statistical reports also. Especially in European jurisdiction, I have clearly seen most of the applicants, if they are unable to still prove their inventive step, they're clearly providing the statistical data, which is clearly showing the performance, increased performance level, or the number of emissions, it is less. In the terms of wastage of resources also, the consumption of resources is reduced. So these points are able to prove with some reports. Then they are easily getting granted.
So ma'am, we can include this comparison or comparative data analysis in the description.
At the time of yes,
drafting only. It would be
in
good.
drafting, if see, not every applicant comes with a ready product which is already ready in his hand. So he comes with the idea, he comes with the general drawings. So if we try to develop that product also, there will be a lot of differences to the original product and the drawings which we are provided. Many of the applications, if the applicant already has the prototype ready with him, then the drawings will never change. It will be same.
Maybe this might be case with the academicians. Mostly they work around publications, and that is why they are having that comparative data with them. So we can like go ahead with while drafting, we can put that.
Yes. If they are able to really, once they see, some people do some market trials also before draft filing, and we have certain limitations, 12 months before doing such trials. From the date of such trial, we have 12 months to file the application. So we have to make sure that is also there. And even also we have to keep one question which is very important. We have to keep informed, like, did you publish this idea anyway? Did you write any article, or do you have your own website, and did you already posted your products over there? We have to ask. If so, then we have to check the date also at the time of publication, because if we are section 29, that's easily they'll point it out. It can be anticipated by the the researchers in the same domain. It is really anticipated. they can, now at that time we cannot fight. And even the problem arises if you publish it in your own product in your own website before patenting it also. So we have to, if it is done in such way, then we have to ask the applicant to remove that content from the web. If we remove, then that's fine, it's not an issue. So these are some other things which we, at the time of practice, when we are saying, we have to make sure that this content is not available anywhere at the time of filing, at least in our own website somewhere. Because this is a general product, it's some food product, they have their own website, it is a startup company. Just one day, with only 1 day span, it crossed the limit of anticipation. And they did not remove it.
But when the applicant says that it is published in a scientific journal before a learned public, then it is accepted. It's not an anticipation, no, as per Patent Act.
See, but you're applying for the patent for the monetary gain, right? You're not just generally applying it, right? Only for the purpose of teaching kind of thing, and that's fine. You can share it anyway. But if you want to do the patent, you're going for the monetary gain itself. No one comes for the patent just to give a patent. He expects some types of monetary benefits from it. So, and also before disclosing your idea, you have 12 months. They have given us a buffer period for us to maintain that novelty. Only to maintain that novelty, they have given us 12 months. The anticipation, that's it. But after 12 months, we don't know, because it's easy as a word to word spread, and during the market trials also, if you have limited the trials to one scope and you're not going beyond some reach to just do the trials, then you'll have a perfect statistical data also. But again, you have to make sure that at the time of filing, you have to make sure that the market trial is done and your product is not in the reach of larger crowd.
Correct.
Yes, and also you have to see that within 12 months you have filed. So you can say clearly, see, my own product, I'm doing a trial research to provide the statistical, to just confirm my statistical data. I have done, but I have filed, because we have the provision, we have the facility of 12 months. We can use that. That's yes, we have that. Actually, many of them thinks that anticipation, those sections 29 to 33 is some kind, causes some negative impact, but no, actually it is a kind of boon for the applicants, because we are having some 12 months. This is not present in most of the jurisdictions. We have that.
Yeah, thank you, ma'am.
Yes. Anything else?
Recently, we come across one scenario. Once the examination report is released and the objections or the inventive step and the novelty by the controller based on the deviations which he mentioned. And he suggested that we submit the response also. He suggested that the hearing to the applicant. We have attended the hearing, and the post-hearing, still the objections are not satisfied, and the objections are still arise. And the controller decided to refuse the application based on the section 15.
Yes.
Now, yeah. So with respect to this, he rejected the application and has refused the application to get the grant. So with respect to this scenario, we challenge the controller decision through request the controller to
review it.
Review it. Like how many times will it go for reviewing, asking for review the controller's decision? How many times the application have the option to review the controller decision?
At the time of controller, we can do it once and we can appeal it. If it's still the controller review is not yet satisfied, we can appeal it for the next court, next further jurisdiction. And at this time, we don't have the controller body, which is already dissolved in the last web. So whatever the review of thing, everything, which it is all automatically directed, especially to these high courts at present. So this review and everything, it's really taking a lot of time. Before we used to have a body, a controller body. Now that body is dissolved. So everything is directed over here, and number of times everything has a limit for it. So we have up to the maximum court. So now we start with the controller, then we go with the high court, then we go to Supreme Court. That's it. appeals. Number of appeals are limited to 2. And
Now, with respect to this case, ma'am, the appeal will be within the patent office or it will go to the High Court?
no, appeal will be within the patent office. The controller board will be decreased. Now, for the first review, it may have a body of 5, and in that they have number of experts will be differing, and there will be one controller. And if we go for the appeal, the number of controllers will be increased. And it goes on. And for the third time, number of controllers. So controllers are some people who are above all the things, and the examiners, and these are the comes under the below the controllers. And we should also have technical experts with them, along with them. So these people will be someone who is outside the third parties who comes in review for this decision of the controller who has given grant or not. So they can verify whether is there still their technical to just come out for the technical aspect, inventive step. This experts, the domain experts are considered, and upon their decision, the controller will take the decision again for the first review. If it is not, if you appeal it again, the number of controllers will be increased.
Okay.
So one or 2. And I think like there is no like restriction for number of reviews as far as I know, because in the rules also they did not mention like limited number of reviews. But seeing that, if you keep on appealing at one stage, there will be a clear thing. It is refused. That's it.
What I heard, ma'am.
But see, still at the time of hearing also, he is unable to get to the inventive step. Then you must have already seen that the claim must be really in the broader scope, the first claim.
Okay.
It is not defining the proper thing. Like we might say, okay, this is working in this. We have several number of advantages. So as I think Kashmir, she was saying that economical benefits. Economical benefits are something which we cannot claim as a technical aspects. So it is not at all comparative to that. And based on economical aspects, only the controller cannot nowhere grant the patent. There should be a technical aspect to prove that technical aspect. If still the examiner is still not satisfied, to prove that technical aspect, we can provide some you can survey reports or statistical data to prove, okay, my CUC in the market, I have given a trial, this is the performance. So you can compare with the existing market products. So this all comes under the technical analysis data. So you have to prove that. So we cannot say like my product, it is using these resources, so the cost of production is reduced. No, that can, so you patent it. No. Cost is reduced, then that is something a business improvement now. So if you say that we are reducing the wastage emissions in such certain way, or we are in this form, and because of that the performance increase, then that is paid.
Okay.
And
that's
that,
like
that's under the that is completely, that is, you can go with sustainable improvements. Those comes under this, whatever you say, cost of production is reducing. These are the economical benefits. You cannot claim for that. Yes, Shanthan, you're saying something?
No, ma'am. I have in line with your addition, but what I heard and what I heard from the people is a one time you can appeal to the controller decision. If then that one time is also over, you need to appeal to the High Court to review his decision and challenge into the.
That's true. In High Court itself also, we have the controllers, we have the body of expertise. So there'll be a technical body, not this general judges and those. There will be one presiding judge who will be there, but they should there will be a group of technical people who goes for these cases. So it is not it is completely different from the general High Court hearings. This thing, they'll be having a separate body for that. They'll be having separate offices for that. So I don't know. We go review, but yes, tell me.
Yeah, sorry to interrupt.
Yeah,
but after patent office, it will be appellate board, IPAB, right? Or nowadays
IPAB,
it is
yeah,
dissolved.
that's what that is dissolved. There is no IPAB now.
It is dissolved completely. So for none of the previous functioning, they are on board.
No. No, the
So-
body is completely dissolved, and now we have to say for everything, now it's directed to the next jurisdiction.
So if we are from Mumbai patent office and we have some issues which are not satisfied with the patent office, so whom to approach after patent office then?
It depends upon the address of communication which we have provided. It depends.
Mumbai address. Mumbai address.
Mumbai address. So now see, if the
Madam, I have a question, madam.
yes, yes. So
If IPAB is dissolved, then
Yes.
will it be given importance in the exam point of view?
I mean, in case of like exam point of view means.
Any questions from that section?
No, I cannot say that because it depends. Like IPAB is really dissolved, I understand, but though his functions, like only the body is dissolved, but those functions are carried with someone else.
Okay,
That's
okay.
right. So there is no IPAB body. Only those people. I mean, the persons who are sitting as controllers or the expertise, technical experts. Those people are not there under the name of IPAB, Intellectual
madam.
Property Appellate Board. But again, those people.
Then there is no
pending the
escape.
same-
Then there is no escape.
No. We did not remove those sections or the rules. They are there, but only that IPAB, the name is, I mean, the structure is dissolved, but those functions, everything are carried by again with the next higher jurisdictions. It
Okay, madam.
comes under the High Court and everything. Those
Okay.
functions.
So yeah, ma'am, I'm
Just to
awaiting
add-
for my ma'am. I'm awaiting for my answer.
Yeah,
Like
yeah,
if
Mumbai,
IPAB
it comes under the address of service, the applicant address of service. So
Mhm.
the jurisdiction, the higher jurisdiction of that state. So if he is from Mumbai itself, then the Mumbai High Court, the jurisdiction takes over that case. If
Okay.
the applicant is from other country, state, then that state jurisdiction will take. Because
Okay.
here,
So basically, it is if the thing is not being satisfied with patent office of that particular jurisdiction, then High Court of that jurisdiction, right?
yes, only that state.
Oh,
Here
So
is
not
the-
high court, not high court. I guess it's district or the civil courts. Right? Because in the document of IPAB dissolvement, it was mentioned clearly that the cases now will be heard under the district courts of that particular jurisdiction.
Yes.
No, sir, I think it's a high court,
High
but the
Court.
copyright related, it's related to the any district court or a commercial
Yeah,
So
commercial.
patents are always with the High Court.
high court. Yes.
Okay.
The other IPs, the copyrights, the trademarks, these are always from first itself before High Court also, they are going with the civil courts or district court.
Correct.
Okay. Sure.
So,
Got it.
but just the infringement cases will be
Infringement is High Court. Infringement is different.
not lesser than district court. It mentions, I think, under section 104 or something,
Yes,
isn't it? In
Yes.
patents also.
yes, for the patents also. Sneha, I think I covered your question. It always depends upon the address of service of the applicant.
yes, ma'am. Yes.
Yeah.
Thank you so much. Yeah.
So here the address of service also counts to verify the, to determine under which jurisdiction it falls. So at the time of filing, it depends upon the agent and the applicant understanding under, mostly it goes with the applicant jurisdiction or always applicant. See, I'm from Hyderabad, but my applicant is from Delhi, then definitely it will be under Delhi jurisdiction. And I can represent anywhere in any patent office because I'm an Indian patent agent, not a Hyderabad or Chennai patent agent. So it depends. Like jurisdiction, it's always under the applicant who should have the address of service in India. If he is unable to have an address of service of India, then the patent agent address of service of India will be considered to determine the jurisdiction. And always, and because patent agent, Indian patent agent is restricted to practice only in India. Anything else, guys?
Ma'am, you're also working in European jurisdiction. You said something.
No, actually, I'm practicing completely in front of Indian Patent Office itself, but we're having a PCT National Place Applications Entry, right? So when we have such kind of cases during the hearing, we'll have the same application filed in number of jurisdictions because it's a PCT application. Definitely, at least the home country, the application. So there, before it is coming in 31st month in India, but before that, the main country, the homeland country, already must have gone to the examination. So here we'll consider all those examination reports also. As an agent, you have to check those, the legal status in each jurisdiction. If it's published, okay. If it's examined, then check the examination report, what type of objections they have raised. And it's really difficult to get the document of how those people have given the objection reply. So FER reply, right? So it is shown in our database, in our public domain. We can easily see FER reply. But in European database, we'll not see the objections. I mean, they don't draft the novelty and inventive step objections. Like here, we will draft easily. Okay, this is this and this. They will directly give it in the time of like an arguments in time of hearing. They will not give a proper written submissions as we give at the time of hearing. In the hearing, after hearing, in the written submissions, we present every point. Whatever we spoke in the hearing, we have to give it like minutes of meeting. We have to give a detailed description, not like a minutes. It is a briefing. In that way, whatever point we speak, we have to give a detailed description, written submissions. But in other jurisdictions, that practice is not possible. So, but we can see what type of objections they have raised there. So we can compare, okay, this is an objection kind of thing. And they clearly point out, this is the point. It is not, it is existing over there. You have mentioned this point, but this is the alternative of this substance. And more specifically, they'll say this is more advanced, like that priority is more advanced than this. It is doing more better than this. So to avoid all those things, if we are able to provide statistical data, then it's fine. Else, then we have to work on that.
So you work on the national his application of those PCT.
We can work as a patent agent. We can work. We can easily work with US applications. We can work with Australia. We can work with everywhere. But in terms of representing that applicant in front of their office, then we don't have that record unless we qualify in their bar. Here in India, we can represent them in front of controller because we are appearing in for hearings. There for the office, they consider those as office actions, not hearing or kind of thing. So for those office actions, we cannot provide our arguments in front of the controller, but we can work for those. We can draft it, we can the arguments. But the person who is qualified for the bar, for their jurisdiction bar, who is qualified under it, he has to represent like us in front of control. So our hearings also will be in the same way, the same online. So the controller will just say, okay, now you have inventiveness. So now start with your arguments. We have to produce that. And we also have limited access. Applicant may, it is his wish. He cannot appear, and the patent agent and the controller, that's it. There is a limited number of people in our hearings to be appeared, and only one person should present. That should be an agent. Or else, if the applicant is ready to provide his arguments, then the agent should become. So there should be only one person. So this is a one-to-one interaction here.
Okay.
Yes. Like, can I know like what is the domain of your science or technology? Like most people, I'm from electronics and computers background.
I am from chemical engineering, madam. I am from chemical engineering.
I'm also from chemistry, ma'am.
I am chemical engineering, madam.
So
I'm a mechanical and automotive.
okay, so
I'm Shantan, ma'am, from mechanical and automotive.
that's me. So in general practice, now apart from pharmaceutical medicines, I'll deal with all the things. Mechanical or these automotive, whatever parts you're saying that, and mostly my domain, I'm more common, like it depends, like we are from I'm from electronics and computers, both backgrounds. So I'm most comfortable with the electronics subjects.
Yeah.
And computers recently, like now, I don't know who asked about this artificial intelligence and everything. They are like, you can just go with these whiteboard. They are giving every time there will be a search, reports, statistical data, how these AI applications are being filed and what type of, how they are examining those applications. Because in PCT, now PCT is done with whiteboard. That is the presiding body for the PCT. So a PCT also, we can ask them to have an preliminary examination report. But again, when it comes to the national phase, the controllers don't depend upon that report or their objections or their comments, nothing. It is, but most of the time will not, the PCT, it is not compulsory to have the preliminary examination report for you with PCT. But search report, they'll be giving a search report at the time that is done, but this is not mandatory for them because the jurisdictions, they won't rely on those things, on the documents or on the submissions. They will. So from each jurisdiction, it only depends upon the controller. So if it is granted in Europe, if you say, so it is not compulsory that it will be granted in India. If it is granted in their homeland, it is not compulsory to be granted here. So it depends upon this. So everything, whatever is the final answer, the final decision or the final take is with controller itself. Our duty is to represent the applicant, the concept in our drafts. So the main our expertise is certain strategies and drafting. How we draft. Anything else, guys? I think I have taken a lot of time, I think. Yes.
Nothing, madam. As the class progresses, maybe some doubts will arise.
Yeah, I'm sure. But if you people want, as I told, if you want any additional information or kind of thing, you can let me know. I'll try to provide it as much as possible.
Yeah,
Thanks for that, ma'am.
Thanks a lot. Thanks a
Ma'am,
lot.
please
madam.
provide your mail ID, please. ma'am.
Meanwhile, can I give one assignment for you today?
Sure, ma'am.
Yeah, sure.
Possible, if you can go through at least the paper 2 of the previous papers. Any paper, it's your wish, I'll not consider. If you go and at least try at the not drafting questions, there is some before questions which mostly depends upon the sections. So they'll give you some case study, and and as a patent agent, what you'll suggest to your client. This type of questions are there. So if you could go through those questions and if you try to solve it, if you find any doubts in that, you can ask me in the next class. So I can just help you out if you find any doubts in those types. So it will be like an exercise. So at least 1 or 2 questions, if you could solve from any paper, and you could show me or present me tomorrow, and if you ask me the doubts, I can clear it up. So I can just say like how to draft those paper you have, because paper 2 is completely a theory based, and you have to do mention a proper terms and everything also in that. And the forms, the fee, and and I can also, like, if I have time, and I can say how the Viva goes. I'll explain. I'll share my personal experience also. So it will we'll have the exercise sections in the last. We have a lot more. Like I have more 9 sessions with you, so I can go ahead.
Okay, madam. Okay.
Sure, ma'am. Thanks for that.
Okay.
Thank you, ma'am.
Yes. So Brijesh, I think it's done for today.
Yes, ma'am.
Yes.
Ma'am, can you share your email ID so that accordingly they will ask you the questions with respect to the exam and other doubts?
Yeah. If you're fine, I can do it. Yes, I've shared in the chat. I think, is it viewed, guys? Yeah, I shared my email ID in the chat box. You can just check it up. It is ojaswini@gmail.com. You can drop me mail if you have any doubts, or if you want any further resources also, you can let me know. I'll maximum try to provide those resources for you.
And Krishna can share it in the WhatsApp group.
Okay.
Yeah.
It is Ojaswini.
Okay, okay, in the WhatsApp group.
Yeah.
Okay.
Light hakina.
Yes.
Thanks a lot, madam. It's really
Okay,
interesting.
yes.
It's really interesting.
Thank you. Thank you for your
Thank you,
feedback.
ma'am.
Thank you. Then I'm leaving class then. Shall I? Or, okay, you people leave, then I leave.
Thank you, ma'am.
Thank you, ma'am.